Okay, let me know when you're ready.
My approach, just to handle quotes and case law, I've got to separate it out. So,
Okay. Thank you.
Thank you, Your Honor.
Okay, thank you. When you're ready to proceed, you may do so.
Procedurally, the objection is Mr. O'Mara's, the evidence is mine, so.
Sure. I objected on the grounds of relevance, and I think the state would now need to show the relevance
Okay.
of the evidence. I could frame it more, but I think the state needs to present why they think it's relevant.
Somebody start.
I'll be happy to, Your Honor.
Thank you.
For starters, I'll point out that the evidence was already admitted. I can't imagine anything more relevant than the fact that it's already before the jury and been partially published. I also can't imagine anything, very few things anyway, more likely to confuse the jury than to stipulate to an exhibit, admit it, publish it, and then attempt to unring that bell. I will simply reference an earlier sort of example of this. We did have on one occasion a juror who had been agreed to be excused for cause, and then the cause evaporated, and the court again said, look, it's already been done, we're not going to go back, even though there really isn't any prejudice demonstrated. It was literally overnight. So I'm going to start with that. Secondly, the issue of relevance. Number one, the state is a little bit uncomfortable sort of giving off a preview just in response to a simple relevance objection, but in this case, the court will hear additional evidence. You will hear evidence about the defendant's neighborhood watch training. You will hear evidence about his prior activities in connection with that, as well as just his prior activities in the community. Some of that is these calls, representative. You will hear about his coursework and how he's been educated. You will hear evidence about his emails to some of his professors regarding his goals for his training. And several of these calls specifically are relevant because, just like the defendant in the call that's already been admitted and played through witness Novke, references people perhaps escaping through the back entrance to the complex and getting away, and he specifically directs officers to go there and worries that these suspicious persons will perhaps get away. The relevance is discussed, legally speaking, section 90.401 and 90.402. And it's important, I think, to parse those phrases. It is evidence tending to prove or disprove any material fact. It doesn't mean it has to prove necessarily an element of the crime. It doesn't necessarily mean it has to prove an element of a defense. Those aren't the only facts in issue, and I would submit that the defenses, both opening and cross-examination, have made several facts in issue, in addition to simply the elements of a crime, a defense, or state of mind in general. I'm going to start with, however, the elements of the crime. and I've given the court the Wimberly case. The Wimberly case was actually a first-degree murder case. Here we have second degree, but in that case the court was very clear, and it's the last page of the opinion. Cases where the defendant's used, and in that case it was actually a racial slur as opposed to simply just a conversation with a police officer, relevant to show the defendant's state of mind as an element of the crime charged. Second-degree murder requires, of course, that the state establish an element of ill will, evil intent, spite, those sorts of things. In that case, the court held that because of the charge, in that case attempted first-degree murder, requiring the state to prove a state of mind, in that case premeditation, that the phrase in question or the evidence in question, the statement by the defendant in question, was relevant to establish an element of the crime charged. The reason I bring this up is because there was some confusion, I think, yesterday regarding the distinction between state of mind as an element of a crime and state of mind as a hearsay exception. And the two things are pretty different, and they're treated differently under the law. So I wanted to first introduce the Wimberly idea that anything that is relevant to establish or prove or disprove the defendant's state of mind meets the definition of relevance. I will also point out that although it is different than the 803.3 hearsay exception for state of mind, that this evidence was admitted as a business record under 803(6). So there's an independent hearsay exception. State of mind exception might be useful and might be something that the court can consider in this situation, but it's not necessary for the admission of the evidence. The admission of the evidence is a business record, and its relevance is established by the fact that it relates to an element of the crime. I will point out that that is the same hearsay exception, 803.3, state of mind exception, which the defense yesterday moved the court to invoke to admit certain statements of the defendant in a completely different context. I will also point out that relevance can be to establish an element of a defense. In this case, the defense is self-defense. Obviously, the state has the burden of establishing that this is also not self-defense. The jury's been so instructed already. It will also include whether or not the defendant provoked the incident, provoked the contact. And I point out I guess it's below, Billeaud case, which should be the next one. Evidence is relevant, and this is also on the last page of that opinion, if it tends to prove material fact. In this case, in the below case, the evidence was of extramarital affairs, and it tended to prove material fact central to the self-defense, the straw that broke the camel's back theory. And frankly, that's certainly one theory that bears a strong resemblance to this case, that this is an ongoing building up generalized frustration as expressed by the defendant himself with his remarks about these assholes always getting away. It is error to deny the admission of evidence in that case. In that case, it was the defendant who wanted to offer it. It was central to his theory, and there was no prejudice shown by its admission. I'm still waiting for any showing of prejudice to the defense as a result of the admission of this evidence. And the excluded evidence, the court said, could have significantly strengthened, in that case, it was the defendant's theory. But certainly the same would hold true if it's the state's theory. So an element of defense, in this case self-defense. Jury instruction 7.4 makes very clear, and the court has already actually in part read this to the jury, it's the homicide instruction. An act includes a series of related actions. Why a particular set of steps? And so the jury is going to be encouraged and should consider the entire context of this. And so the reason that the defendant takes particular steps and prior steps that he has taken, which might be related, certainly should be admissible. Other facts in evidence, other facts in issue, I should say. Number one, motive, and as I've already said, state of mind. I provided the Hart case to the court, and it's the necessary language, or the language I'm relying upon is on the first page in the second column. Motive and intent are states of mind usually inferred from the conduct of the parties and the surrounding circumstances. They are questions for the trier of fact that are generally, in this case it was a motion to dismiss, but we're talking about the bare relevance of this testimony. Motive and state of mind are classic jury questions, and the jury has a right to hear evidence that might relate to establishing those things. In this case, we've heard about profiling. as a state of mind, and the motive for seeking out this particular individual as opposed to prior calls where the defendant did not follow the individuals. There is the issue of whether or not this was, as the defense stated in their opening, simply a concerned citizen, or whether, as the witness stated yesterday, this is evidence of hostility. There is a fact and issue as to whether the defendant merely observed or actually profiled and did more. I will point out that the first words on the non-emergency call that has already been admitted, the call to Mr. Nofke, the defendant says, yeah, there's a real suspicious guy. And his second phrase is about prior break-ins. I think the states should be allowed to establish through relevant evidence like the prior calls whether or not the defendant's allegation that he's suspicious simply because he's walking around in the rain is one thing, or if he considers a lot of other things to be suspicious in and of themselves. So it's the credibility of his comments. The second phrase, the prior break-ins, is it suspicious because he's had prior break-ins, or is it suspicious simply for some other reason? Those are facts that the defendant himself has placed in issue. Again, another fact and issue, why he follows this particular person. And again, it's because these other assholes, and he's describing these other calls as other people, always get away. And actually, I'll give it a little preview of the evidence, that two of the calls, two of the reports, indicate that the police actually contacted someone, ran their names, and let them go. What is the impact of these prior incidents on the defendant? That is why I provided the court with the Eugene case, which is the next one in. And this should be on page 4 of the opinion, beginning under head notes 2 and 3 discussion. A statement may be offered to prove a variety of things besides just the truth. When a statement isn't offered for the truth of its contents, but to prove some other material issue, it's not even hearsay. And one of those recognized exceptions is to show motive. They continue on in the next column. The statements they concluded in that case were non-hearsay because they established both knowledge and motive rather than establishing the factual truth of the context. They show at the bottom of that paragraph the effect it has on the hearer, the impact on the listener's or the person's state of mind. That is exactly the reason that the state is proffering these prior calls. It's the impact of these prior incidents on the defendant's state of mind. We're going back again, some calls within about anywhere between 2 weeks and 6 months prior to show the building level of frustration this defendant had with calling about suspicious people, not following them, and having them get away. He even, again, as I mentioned earlier, repeatedly references the back entrance to the apartment complex. He also, in each of these cases, in some of these calls, has specific knowledge of addresses in front of which these suspicious people are. So again, the idea that the defense has placed an issue about whether or not he knows addresses, I think, is a fair fact that makes these calls relevant. In an opening statement, we heard that he purchased his gun simply to shoot his neighbor's dog. I think that is now a fact and issue as to the reason that he actually purchased the gun in the first place. Other facts and issue. The cross-examination of Mr. Nofke implied that the defendant might have only followed a supposed suggestion by Mr. Nofke to get more information and how Mr. Zimmerman would reasonably have interpreted those words. The fact that he has called these number of occasions prior and understands the language of dispatchers and has had these prior interactions, I think is now relevant to establish that that construction of a suggestion by Mr. Nofke that a defendant might interpret it that way when he has never interpreted it that way before, now I think is a fact and issue making those calls relevant. He is not a naive caller. Finally, the admissibility of this. It is admissible in its own right as a valid business record. I will point out that the final theory, and this is represented by the next few cases in the stack, is that this is actually evidence that's kind of intertwined with what's going on, and I've sort of alluded to this already. I'm going to point out, start with the Cameron Holmes case. And in that case, we're talking about, again, a murder charge where the defendant had engaged in some prior drug sales and went back on a later date to collect from the scene and ended up shooting another person. who is unrelated to the person that he had sold drugs to. In other words, that he himself created that scenario. In this case, the Holmes court said, typically there's 3 reasons that you can admit such type of evidence. 1, it's necessary to establish the entire context out of which the charged crime arose. 2, necessary to provide an intelligent account of the crime charged. And 3, necessary to adequately describe the events leading up to the crimes. To prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crime charged. That is exactly the reason that the state believes that this evidence ought to be admitted. It ought to be admitted because it shows the context in which the defendant actually sought out his encounter with Trayvon Martin on the night of February 26, 2012. The evidence, the Holmes court went on to say in the right-hand column, and I'm reading from page 3. Sorry, I should have directed the court. The evidence which appellant sought to exclude showed a continuing chain of chronological events without which an intelligent account of the criminal episode could not have been given and was necessary for the state to be able to show the appellant's state of mind. They continue to say, although this evidence was prejudicial to the appellant, almost all evidence introduced by the state in a criminal prosecution is prejudicial to the defense. Appellant's credibility was at the heart of this case, and it would have prevented the state from fairly and adequately making its case against appellant if the evidence was excluded. That is squarely the situation we have in this case. I would also point out that the defendant himself created these calls. He created these tapes. He created the situation. He's essentially responsible for everything that has been admitted so far. It's him that picks up the phone and makes these statements. So he shouldn't be allowed to complain about it. The Vail case and the Alford case, which are the next two, kind of relate to my prior Holmes argument. Vail case, the last page of the opinion, again, the evidence inextricably intertwined with the observations and investigations the police held before and during the arrest, relevant to the defendant's admissions after his arrest. The sudden turnaround in his statements, the admission of guilt, confused the jury. Evidence of a collateral crime even, necessary to establish the context of events and to describe the investigation leading up to the arrest and subsequent confessions. So again, we're talking about assisting in establishing context of a homicide here. The Alford case is a little bit older, it's from 1975, but the premise is essentially the same, and the operant language is essentially found throughout. In other words, this is evidence that's relevant to establish context in other things. It doesn't have to be solely relevant to prove an element of the crime. These are other facts in issue. I'm going to move on next to the idea that the defendant himself created these calls, and this is the Jones and Adams case, both of which cite an older case called Mardoff. In the Jones case, it's a single-page opinion, and I'm reading from the right-hand column. In this case, we're talking about more evidence, and in this case, it was an inflammatory type of photograph. But they said it was relevant to the issue of the identity of the deceased, the defense, in this case, the defense of suicide, and the cause of death. They quote the Mardoff case, where they said it is not a valid objection to the admissibility, in that case of photographs, that they tend to prejudice the jury. Competent material evidence should not be excluded merely because it may have a tendency to cause an influence beyond the strict limits for which it's admissible. And they go on to give yet another quote, which I think is apropos for this case. The defendant could not complain because of the shocking nature when the horrible scene disclosed was one which he himself created. That's Jones. Adams also cites it, essentially the similar language. So from the state's perspective, Your Honor, the evidence is admissible because it relates to an element of the crime, it relates to a potential defense, it is relevant to a number of items which are now in issue, some of which have been all along, some of which have more recently become so, and it's already been admitted, and there shouldn't be sort of a let's try and take it back. So the state's position is that the evidence is clearly relevant to all those things, therefore the relevance objection should be overruled.
Thank you. Mr. O'Mara?
Yes, if I might. We certainly agree that 401 talks about if it's relevant, it's admissible, as does 402. But the reality in this case is that's not the focus of the evidence code. What they're trying to do, now that I see what they're trying to get in, I was curious as to how they were going to relate that to some issue, and now at least I see their point. This is traditional 404 evidence. What they're trying to do, forget the fact for a moment that the evidence is not bad act evidence, because normally 404, you're trying to get in something that the defendant did poorly or badly in the back to say he acted badly then, he acts badly now. But nonetheless, it is previous acts, Mr. Mantai's own words, previous activities of the client. This is traditional 404-2 evidence, which in effect is an attempt to bring in similar fact evidence. Client acted in a certain way back there, and therefore you should be able to let it in now. Well, a couple of things with 404-2. And let me start with my initial response to their opening suggestion that we waived it. If in fact there is a concern in this court's mind that it's been waived, maybe the first one, that should fall on counsel. Into the future, that should not affect my client's right to a fair trial with evidence which would otherwise not be admissible, but for a handwritten stick to try and avoid the necessity of putting in photographs and other pieces of evidence. But having said that, if we really do an analysis of the evidence code, we have to look at what the state is trying to do. We know now from their voir dire that they have little, if any, direct evidence to support second-degree murder. Argument, yes, but it seems as though they're presenting that this is going to be a circumstantial evidence case. And their circumstance now, we know, is going to include some prior acts of Mr. Zimmerman, who in the past has called and said, think there's something going on here. Primarily, I think you need to listen to all of the calls to determine whether or not what I just said to you is accurate and whether or not they would fall in under 404-2 prior bad acts, if they're bad acts, or if they're just not relevant because they aren't even properly noticed. Because, of course, under 404-2, if it's in fact similar fact evidence that they're trying to get in, they would have to have noticed this 10 days before trial. We would have had a hearing on that. We would have vetted through much better than we're doing today the idea of why that evidence ever becomes relevant to the court. Because if in fact you were to allow this evidence, if it is in fact relevant, then what is it relevant to? State of mind. To get to, under the state's theory, ill will, hatred, second-degree murder, the element of second-degree murder that makes an act a crime. If you were to listen to these tapes, and I truly think we're going to have the time for you to do so to understand the validity of this argument, those are not acts which show ill will, hatred, second degree. What they show you, what they would show you, is he was acting fine. He called out, my wife, there was a burglary here, my wife just saw someone pass by, and here's a description. Oh, there's some kids out there, I don't know who they are, whatever. In effect, what the state is going to show the jury, if you allow that evidence, is 4, 5, or 6 acts where my client has contacted the police to say, hey, come check it out. None of which is going to show ill will, hatred, spite, second degree. Then what they're going to do is say, aha, remember we told you about profiling? Well, now we want you to presume that when he acted reasonably those 5 or 6 times, he was seething under the surface. He was just building up. They talk about evidence and say this is similar to affair evidence. So he was having an affair for the last year. So the fact that he came and killed somebody, the affair evidence is relevant because it shows the bad act. It shows the seething nature of his activity. This is like arguing that he was sleeping with his wife in a rape case. It doesn't, there's no connection. What they're asking you to do by admitting the evidence and then going to ask the jury to do under 404 is to take those prior acts and to presume that he acted in a bad way. We can't see it. The facts, the evidence they're going to admit, if you allow it, doesn't show ill will, hatred, bad act, or anything under 404-2. and I'll go over the case law in a minute, that suggest that that would get in against the defendant. What they're trying to do is show 6 prior acts where he calls the cops responsibly and argue to the jury circumstantially that he is, I don't know, too responsible or too good in calling the cops. So that's the context of what it is that they're trying to get in. Now let's look at some of the case law that I presented to you, and it's quite instructive as far as what you have to do when looking at whether or not any prior act of my client should come into evidence. Anything outside of the 7 or 8 minutes, February 26th, 2012, starting at about 7 p.m. that night. If we're going to go backwards in time and say, let us look at 5 or 6 prior calls of the defendant so that we can argue that we want you to presume some bad behavior, at the very least, Your Honor, I would ask that we not allow it in at this point until the state shows you the connectivity, the connection that they have to make. They can't just argue it to a jury. They have to have some evidence to say to you, now we've shown George Zimmerman as this whatever they're going to show. And now this evidence is now relevant because we have the seething phone calls. They don't have any of that. They're going to be asking this jury to make a quantum leap from good, responsible citizen behavior to seething anger. Not the least of which we can't forget, the only person who's testified in this courtroom so far about my client's behavior, the seething nature of it, or actually the non-seething nature of it, is the one who was talking to him on the phone, Mr. Nofke, who said, I heard nothing. I heard the words, didn't mean anything to me. Didn't raise my spidey sense at all. Didn't make me think about anything except routine phone call. Never even got to level 2 on his little cheat sheet as to what it was. So let's look at the case law to see whether or not this evidence rises to the level, ignoring for a moment the procedural difficulty with the fact that if it is in fact similar fact evidence, which is the only reason why it should come in, Williams' rule is a generic term, 4042 is the evidence code, and what it says is you have to have 10 days notice. But putting that aside for just a moment, let's just say that we were in a Williams rule hearing pre-trial and they properly noticed it. I think it's fatal that they did not, and I'm not waiving that, but just to argue the substance rather than the procedure, let's look at some of the cases that talk about similar fact evidence. One, it has to be so similar in fact that it assists the jury. So if these phone calls, which is why I mentioned a moment ago, you really may have to listen to them. If these phone calls were something that evidenced, I'm using the generic term, seething behavior, anger, animosity, ill will, hatred, if in fact those calls evidenced that, then the state might be in a slightly better position to argue to you, Judge, he might have been more subtle with phone call that we have, but this is who he is. Listen to the ill will here. Listen to the hatred there, and then maybe argue to the jury, it continued. He was just more subtle this time. But the 40442 truly says it's got to be very similar. And the reason for that is we know under 404.1, that evidence of his character, which is really what they're trying to do, his character is at issue. They can say state of mind, but it's character. It's who he is and how he acted in conformity with that state of mind or that character. And we know that that's not admissible usually, and it's never admissible by the state under 404.1 unless we put it in issue. So 404.1 says evidence of a person's character or trait of character is inadmissible to prove action in conformity with it on a particular occasion, so, which is, I guess, in a bizarro kind of way, what they're trying to say, because they don't have bad act evidence, they just have good act evidence that they're trying to say, look between the lines, circumstantially look between the lines. 404.1, except character of accused, evidence of a pertinent trait of character offered by an accused comes into evidence. If we decide that we raise it and have the ability to, from an evidentiary standpoint. or by the prosecution to rebut that trait. So, under 404.1, if they're going to try to get it in, then they would have to have it as a rebuttal to a trait that we would first present, and they can say, here's some bad character evidence because he made his character good. Again, well too premature at this point because we haven't put anything at issue yet. We haven't begun our case.
Let me ask you this. Comments in an opening statement create an issue in the case.
No, it's not evidence.
Well, I know it's not evidence, but does it create an issue?
You're going to tell the judge, you're going to tell the jury to ignore it, and the instructions say ignore it. And we have great leeway, and certainly in this case there was great leeway with emotion and with fact, none of which was anything but supposedly a roadmap for where they were both going. So it's not evidence. And if in fact it becomes evidence, if there's something in this courtroom that says now it's relevant, then it's admissible. But I don't think that opening statements have now opened the parameters of the evidence code. So,
what about cross-examination of Mr. Nofsky?
That's evidence.
Right.
Sure.
So does that create an issue?
Well, let me follow through in my mind what I think you're saying. The fact that Mr. Nofsky says that there was no animosity in his voice, does that create an issue? Is that sort of an inquiry?
Well, I'd have to go back and listen to the entire testimony, but did it create an issue on the cross-examination that how Mr. Zimmerman was acting and the interpretation of what the instructions were given to him by Mr. Nofsky? Does that create an issue?
Let's presume for a moment it does. I hear what you're saying. I don't think it opens up an issue such that the state can bring in 404.2 evidence that they haven't properly noticed that is not proper similar fact evidence. They can't just say, now everything's relevant so we can start talking about his past. Let's not forget that if we go into Mr. Zimmerman's past on these 6 events suggesting, and again, I'm presuming that you will agree that my rendition of the facts is accurate just for this argument. If in fact those calls show proper behavior, no ill will within them, then we have now just opened up Mr. Zimmerman's history for rebuttal of the, I guess, presumed under the surface ill will and hatred that you're not going to hear in the calls themselves. You're not going to hear in the words. So now, are they now making, improperly under 404.1, his character an issue? I think at the very least, we have to put it in issue first into 404.1. But, and I don't want to shotgun approach the 404 argument
well, that's my question. Did you put it in issue in the cross-examination of Mr. Nofsky? By saying he didn't act aggressively, let's say. He didn't. Well, there are other questions, and I don't want to misquote the testimony, so I'd rather go back and listen to it. Okay, let's say this. Let's say we did, just for this portion of the argument, let's say that we put in issue that he did not act in an aggressive way or that he followed Mr. Nofsky's lead in getting out of the car, whatever it might be. Then, okay, if it's an issue, they still have to follow the proper evidence code to get it in. So within the context of what happened on February 26th, absolutely, that's going to be wide open. Once they go back in time, we then still have to look at 404. That doesn't open the door to make everything that Mr. Zimmerman done in his life relevant. I would imagine that would not be your ruling. So if in fact it even suggests that we have to look at Mr. Zimmerman's, what he did he follow Mr. Nofsky's suggestions or instructions, or at least I said he wasn't acting hostile, was he? And that's now at issue. They still have to follow the evidence code. So if they're going to... I'm thinking that, and again, I'm not quoting because I haven't gone back and listened to the tape, but I think I recall that there was a question of Mr. Nofsky of how something he said may have been misinterpreted by Mr. Zimmerman. Therefore, Mr. Zimmerman acted in that way.
Absolutely. So. I think the question was this, and I said, so when you said, what's he doing next, twice, or where is he running to, do you think that could have been, wasn't as artfully done today, hopefully it was done yesterday, do you think that he may have interpreted that as an instruction by you to go find out? That's, I think, what you're talking about?
Yes.
Okay. Let's say that's an issue. I'm not arguing the point that it's not an issue as much as I'm arguing the point of the procedure that has to be followed in order to get relevant evidence before this jury.
I understand where you're coming from.
Okay. So as we look at the cases like Thompson versus State, Johnson versus State, first of all, it has to be similar crime or fact evidence. And all, there is not, let me say it this way, there is not a case that we have found, and I challenge the state to present one, where prior acts of good acts, prior good behavior, is ever presented to a jury for purposes of showing motive, bias, and whatnot.
What I have to sort out is that basically both arguments are apples and oranges. You're arguing Williams rule and they're arguing 803.
Okay, I think they're arguing
and I'm familiar with both of them, but I need to make a decision as to what portion of the evidence code applies here. So I do understand both arguments, and you may go on with that.
To be clear, they're not arguing that this is a hearsay exception.
Right. They're
arguing business records, but
they're not arguing Williams rule.
Right. What they're saying is it's relevant. And what I have said is, no, it's not.
I understand you, so let's go through the cases.
So if we go through some of the cases, what all of these cases say, and I think what the law in the state of Florida is that the state first procedurally has to give us 10 days notice. But more importantly, the prior act has got to be one that shows the state's case. Makes sense. It has to be relevant to prove a material issue on the state side. So, you know, I feel like I'm arguing the Fry evidence to you again, which is we don't mind the Fry evidence coming in. It's just going to confuse the jury, and it doesn't make any sense. And what I'm saying is I don't mind 6 evidence positions of my client coming in to show he acts responsibly and appropriate to the law. So I should just sit down and let it in and then argue to the jury. That's exactly what he did. There's no evidence to counter that he did that in this case. But the reality is, what I'm saying to you is unless it is absolute relevant evidence to this jury to consider, I don't think it's fair to put in prior good acts because there's no provision under the evidence code.
I understand your argument. I just want to go over the stack of cases.
Let's go over the stack of cases.
Okay, thank you.
All of which suggest prior bad act, and from Johnson versus State to Billy versus State, which is pretty good. Again, we couldn't find any case. I'm going to argue the prior bad acts as though it applies. King versus State, I think, is a good case I would focus you on because what that states is, that was sort of the case of, in that case, the prosecution in a second-degree murder case brought in evidence that the defendant fought with a prior wife. So they sort of said, bad act, he did it then, and we want to show that he had ill will and hatred towards a prior wife. He has ill will and hatred towards this one. And if you look at the analysis in that case is pretty good, and they said not admissible. Not admissible. Not close enough, not factually specific enough to say even though he may have beaten up a prior wife and is on second-degree murder for this wife, that's not relevant. So it shouldn't get to a jury unless, in fact, the evidence is going to help them decide a material issue. What is the material issue that here's the real question. If, in fact, it's relevant, it has to be relevant to a material issue. They want to say state of mind, because that's what they want to get to the jury. But the state of mind that it has to get to is guilt. Presumably, they're not going to prove state of mind of non-guilt, so they want this in for state of mind of guilt. Look at the evidence before you decide and tell me if any of those pieces of evidence, individually or as a whole, evidence guilt. Because if they do, maybe the state has proven their case. My fear is that they're going to try the circumstantial evidence jump over the Grand Canyon to try and get the jury to say, he acted so nicely here, he must have been seething with anger. Finally, he blew up. Well, connect the dots, and maybe they can argue that. Don't connect the dots with prior good acts, because that's what the, the case I just cited, that's what the King case said. Going forward, the Morejon, M-O-R-E-J-O-N, at 394, 7th, 2nd, 1100. If, in fact, in that case, it has to be relevant to the client's state of mind at the time of the event. Nothing of this evidence suggests at all how my client acted at the time of this event. Nothing. And if, in fact, they're going to try and tie those dots together, then they are woefully inadequate today. Maybe after a few more days of state testimony, they can come back with a better argument to suggest to you that, in fact, this should be allowed in to tie up one or two loose ends, but not as substantive evidence to prove ill will without something more. Because today, with the evidence we have right now, that's all they have. They have nothing, and now they're trying to present a sort of a stealth argument that we want you to believe he's bad because he was so good in the past, he must be angry. And realistically, state of mind, from what I understand it, doesn't negate the rules of evidence. They can't just say state of mind lets everything in. State of mind is their argument. They have to follow 401, 402, 403. And of course, 403 then is one of the gatekeeping rules that we have to say, unless it helps them, we're not going to confuse them. So I would ask the state or you, after look at the evidence, to consider whether or not evidence of prior good acts is going to confuse this jury rather than help them. And if so, the state should show to you how it does that before we potentially infect juries, this jury, with evidence that does not connect up that evidence to the state's case. So there are a lot of cases. I would just say that it's not relevant just because the state says it is. I think they need to present it to you ahead of time. If, in fact, you believe that a 404 analysis is appropriate, you do need to address the issue of the procedural fault on the state. I will tell you that I think the procedural remedy is akin to a Richardson inquiry to see what has happened in their failure to. But substantively, this is just prior act evidence that is not so similar in act or fact that it should be admissible before this court. It's certainly not before the jury.
Okay, thank you. Response?
Thank you, Aaron. We've had now a bit of a bait and switch and a series of straw men. The objection made yesterday was that it is irrelevant. That was what I've been under the impression we were addressing today. I heard 404, I heard 403, I didn't hear 402. 402 and 401, more specifically, are the relevance sections. That being said, relevance, of course, is a really low hurdle to meet. Bare relevance is often the phrase that we hear. I want to address a few things. Number one, state of mind of guilt and consciousness of guilt have been used interchangeably in terms of their definition by Mr. O'Mara at this point. They're not the same. State of mind of the defendant in this case doesn't have to be consciousness that he's guilty of murder. It's an inappropriate phrasing. His state of mind is relevant because that is an element of second-degree murder, ill will, whatever. If I need to spell it out a little further, this is not evidence of good acts. It's not evidence of that sort of thing at all. Nobody is alleging that these are good acts. What the evidence is relevant for is to show that on December 26, 2012, the defendant engaged in a series of acts and a pattern of behavior and a gathering of circumstances, February 26 of 2012, which is very different than he knows he should have behaved and that he has in fact behaved before. The implication, I think the court hit on it squarely, the implication yesterday in the cross-examination of Mr. Nofke was well, he was just kind of misinterpreting and thought maybe you wanted him to go fetch information or follow. And that certainly is belied by the fact that he has had all these prior contacts. So nobody's calling this good act evidence. In fact, what is relevant about it is the fact that you can see that he has, again, on prior occasions, called to report suspicious people, knows how to do that, knows what not to do, and the frustration builds. That frustration is expressed in his non-emergency call on February 26th to Mr. Nofke about these assholes always getting away. It's repeated during his interviews with the police when he again references, I've called before, these guys get away, and in several of the calls, as I said, he specifically references they go out the back entrance, just like in February 26th, 2012. Same direction, same entrance. So its use lies in its comparison. And what is different about this defendant's state of mind on February 26, 2012, having now experienced all this, than it was before? The state has to prove that his state of mind on February 2012 was not good, for lack of a more exact phrase. And that does it. It delineates in stark contrast the difference between what he knows to be appropriate behavior and what he did on February 26, 2012, and how he described it. The words, they always get away, those aren't any words but his. And the fact that he said them that night, in that context, makes this relevant evidence. Number two, some kind of allegation that this is 404B or character evidence. 404B is the rule about other crimes, wrongs, or acts. Number one, case that Mr. O'Mara even himself provided, Gardner versus State, says at the very last page, in the very last paragraph, no, that 10-day notice thing isn't absolute anyway, because the only way that lack of notice is prejudicial or isn't harmless is where there's showing of actual prejudice and unfair surprise. In that case, they said, they cited the Pale case, which says it's harmless where it's apparent the defendant knew of the evidence and knew of the state's intent to introduce it. He's had this evidence for months. This witness has been listed forever. There's no question about that. So if we want to talk about the actual wording of the rule, let's talk about that. There is no immediate fatality or procedural problem. Heck, they stipulated originally to the admission of the calls. This isn't some secret. Number two, let's briefly reference the 403 standard, which is the prejudicial value and probative. I'm going to point out again, and I'm going to come back eventually to the Holmes opinion, that that's not actually what the rule says. The rule says that the only way that that evidence would be excluded under that subsection is if its probative value is substantially outweighed by the danger of unfair prejudice. That's not been alleged, established, or shown at all. It almost is a concession that there is some probative value here. Finally, Your Honor, I want to talk about 404B because I heard Mr. O'Mara tell the court that it requires that the incidents be strikingly similar or very similar. That's not true either. The only time that is necessary is when the state is offering evidence under 404B to establish the identity of the perpetrator. For any other purpose, there is no similarity requirement whatsoever. For identity purposes, they require it be, I think the phraseology is fingerprint type evidence. So if we're going to talk about all these other sections sort of as a surprise, because again, the objection was relevance, nothing else, let's actually quote them correctly. Your Honor, the Holmes opinion is about as close, I think, to on point, and I referenced it before, as we get here. That is, the evidence here isn't 404B anyway. It's not character evidence. It's not other crime, wrong, or act evidence. It's evidence that's inextricably intertwined to show the defendant's reaction to his experiences and why on the night of February 26, 2012, he undertook a series of actions, certain steps. It is evidence which paints an accurate picture of the events surrounding the crime charged adequately describes his deeds, shows a continuing chain of chronological events, and is necessary for the state, or at least helpful for the state, to show the defendant's state of mind. I don't necessarily need to establish his state of mind in August of 2011, or September of 2011, or October of 2011, or earlier in February of 2012. I do need to establish what was in his mind on February 26, 2012, and how we can do that is we show that his actions and behavior that night are very different from his other actions. It's not being offered to prove his character or that he behaved well. It's to show that something happened that changed his mind, that caused him to refer to these assholes always getting away, that caused him to call them punks, that caused him to get out of the car and follow him. That's what makes it relevant. And so to call it 404B evidence is incorrect, it's misleading. If anything, it's inextricably intertwined, which is not required to be governed by 404B. It doesn't require notice, and that is the whole focus of the Holmes opinion, or part of the focus. It is relevant to many issues, not the least of which is the defendant's state of mind. The state also, I want to point out one other thing I want to correct about what we just heard from Mr. Mara. I'm allowed and required, actually, to establish or to address the self-defense in this case. A fact in issue, relevance, pertains to not just the elements of the crime, but elements of a defense, whether it's justifiable, whether it's provoked by the defendant, and any other fact that has been placed in issue. The defendant's credibility and his statements and his actions are all facts in issue. And for that reason, the state's position is these calls are relevant. How the defense chooses to spin them is not. Thank you.
Okay. Both sides have handed me a total of 20 cases this morning that I have just perused, and I'd like to get to look at them even more, and I also want to rehear on the tape the testimony from Mr. Nofke, the directing and cross-examination. Mr. O'Mara has suggested that I listen to the tapes. Oh, okay. Can I get a copy of those? Okay. All of them are on the exhibit?
All those that the state is seeking to introduce. I think we talked, and I know I heard 6 reference. There's 5 that the state has.
And they're all
used.
on that exhibit?
They are all on that exhibit.
Okay. Does the state have another witness you could go forward with today until I have the opportunity to read those?
I actually have 2 alternative suggestions. One, I think we do have another witness, but also Ms. Rumpf isn't just talking about the non-emergency calls. She's also going to be introducing and laying the predicate for the admission of the 911 recordings themselves. I don't think those are nearly as controversial as this has apparently turned out to be. So okay. She could actually continue with her testimony on those matters right now.
Okay. Well, let's go ahead and do that, and then I'll listen to the testimony, the tapes, and after court today, and the case law.
If I might, I just want to make sure, because my understanding is there's a category of 6 or 7, and if there are 5 being presented, maybe I didn't know which 5 and which ones aren't being presented.
Do you want to play them in court as a proffer?
As long as I get a copy of what you'll be listening to, I can do it on my own.
Well, so there's no question of what I'm listening to. Do you want to proffer? Okay, let's go ahead and proffer exhibit. Was it on 171 or 172?
I believe it's 171 is the actual recording. 172.
Okay, let's go ahead and proffer 172.
Hey, our neighborhood got burglarized or robbed today, and my wife, I saw one of the kids that did it, and...
Just so we're clear, we can keep track. They're playing through, but I'm not certain we don't have context.
Do we have a date?
Date, sure. Time.
The calls are as follows. First one is going to be August 3rd, 2012. Second is August 6th, 2012. I'm sorry, 2011, both of those dates. My apologies.
I'm sorry, what?
It's 2011, not 2012. August 3rd, August 6th, September 23rd, 2011, October 1st, 2011, and February 2nd, 2012.
And do you know the time of day?
Not without looking at the reports. I know the first one is about 6:45 p.m. Candidly, I don't remember the exact times on the rest.
Is that indicated on Exhibit 171?
It is. They are, yes.
By date and time?
It's on 172 as far as the...
Okay.
Yes.
I just want to make sure that we have an exact copy of what the court's about to listen to that's going to go in, because if that only has 5...
It's already in.
Okay. It may be less than what we have. I just want to know which ones they are. So I'll follow along. We'll figure this out at a break.
Airport Police Department, the line is recorded. Petra.
Hey, our neighborhood got burglarized or robbed today, and my wife, I saw one of the kids that did it, and we see someone that matches his description in the neighborhood right now, again.
Okay, and what's your address out there?
I'd rather not give out my address because he's obviously in the neighborhood, but it's Retreat View Circle. You can use 1111, which is the clubhouse.
Okay, so does he live in the neighborhood, or he's just out walking?
I don't know. It's the first time I've ever seen him.
Okay. And what is your name?
My name is George.
And your last name, George?
Zimmerman.
And your phone number you're calling from?
407-435-2400.
Okay. And is he white, black, or Hispanic?
Black.
And what's
My
he
wife
wearing?
talked to Detective Walker and gave him a description of the guy we see now.
Okay. And what's he wearing right now?
A white tank top and black shorts, and brown sandals and black socks.
So he might be like 5'11". Okay. And is he walking?
Yes.
Okay. And so is he near the
back entrance to the neighborhood?
So he's at the back entrance?
Yeah.
Just went between the houses now.
He just went between the houses to the back?
Yes.
Shoot.
He was looking at the car.
I'm not. Why not?
Don't call. Okay, we'll get an officer out there, check the area.
Okay, thanks.
You're welcome. Mine is recorded. This is Nicole. How can I help you?
Hi, there was a break-in in my neighborhood recently, and 2 youths that matched the description of the people. My wife ID'd them and saw them. They're back in the neighborhood.
What's the address?
You can use 1111 Retreat View Circle, Sanford, Florida, or you know that.
Twin Lake Townhomes?
Yes. Yes.
Okay. And what do they look like? Are they white, black, or Hispanic?
Black males, 2 black males in their late teens. One's wearing a black wife beater, black tank top, and black shorts, and the other one's wearing a black shirt and blue jeans. And they're at the back gate of the neighborhood.
Okay. Approximately how old are they?
Late teens.
Okay. You want to leave your name or number?
I can leave my name and my number, and I'll actually be at the back gate to let the officers in because there's no code there.
What's your name?
It's George, and it's 407-435-2400.
Okay.
If you'll let the officers know, they typically run away quickly, and I think they head over to the neighborhood, the next neighborhood over, so you may want to send the unit over to Calabria Cove.
What's it called?
Calabria Cove.
Okay. Yeah, call. All right, I'll let them know, and they are on the way, okay?
Okay, thanks.
All right, thank you. Bye-bye. Sanford Police Department, this line is being recorded. This is Vicki.
Hi, Vicki. My name is George, and I live at the Retreat of Twin Lakes subdivision.
Okay.
I'm part of the Neighborhood Watch. And I just wanted to let you guys know that somebody left. We've been plagued with some robberies, burglaries, and somebody did leave their garage door open.
Hold on, sir, 1 second. I've got my units calling me. Hold on. 1512. 10-4, sir, go ahead. 10-4, stand by. Hold on for me just 1 moment, sir. I apologize.
No problem.
Sanford back to 1512. Reference Justin McKinney. 1029P at 1054. No local. Showing a valid DL out of Manhattan, Kansas. At 2310. Okay, somebody's got their garage door open, you said?
Yes, ma'am. Yes.
Okay, do you know the address of where the garage door is open?
As far as I can tell, because it's poorly lit, I believe it's 2040 Retreat View Circle. Of course, Sanford, Florida.
Okay.
House.
And you said there's been a lot of break-ins there lately?
Yes, ma'am. We actually just had our neighborhood watch meeting yesterday, and Sergeant Herx came out here, and Officer Buchanan,
Okay.
told us to report anything suspicious, and it's late, and they usually don't have their garage door open all night, so.
Okay, and George, what is your last name?
Zimmerman.
And what's the telephone number in case we need to call you back?
407-435-2400.
Okay, are there any cars in the garage or the driveway just so we can make sure we're going to the right?
Yep, there's in the garage, there's a silver Nissan Xterra.
Okay, we've already got an officer heading that way, sir.
Thank you, ma'am. Have
Sure,
a great
thank
night.
you. You too. Bye-bye.
Bye-bye.
Lieutenant Sanford Police, this line's being recorded. Sharon speaking.
Hi, I was just calling because we've had a lot of break-ins in our neighborhood recently, and I'm on the neighborhood watch. And there's 2 suspicious characters at the gate of my neighborhood. I've never seen them before. I have no idea what they're doing. They're just hanging out, loitering.
What's the address?
1111 Retreat View Circle. And that's Sanford,
the
Florida.
Twin Lakes townhouses?
Yes, ma'am. No, I'm Retreat at Twin Lakes, yes.
So, yes, that was Twin Lakes townhouses?
Yes, ma'am.
Okay, great. Can I get your name and a callback number?
George, and it's 407-435-2400.
And George, can I get a last name?
Zimmerman.
And Mr. Zimmerman, can you describe the 2 individuals?
2 African-American males. They looked, I know one was in a white Impala.
How old did they look to you?
Mid to late 20s, early 30s.
They're in a Chevy Impala. Did you get a license plate?
A white, no, it's a white Chevrolet sedan. It's either an Impala or a Lumen of it. I think it's an Impala.
Can you still see them?
No, ma'am. I didn't want to attract attention.
How long ago were they out there?
Just, 10 seconds ago. I called as soon as I saw.
We'll send someone out there and see what we can do, okay?
Thank you, ma'am. Have a great night.
You too. Bye-bye. Sanford Police Department, this line's been recorded. This is Renee.
Hey, can I get an officer to 1960 Retreat View Circle?
Your name?
George.
You said 1960?
Yes, 1960.
What's going on there, George?
I'm with the Neighborhood Watch, and we've had some burglaries and vandalisms lately. And this gentleman was walking in the neighborhood. I've seen him before on trash days, going around picking up trash. I don't know what his deal is.
Is he white, black, or Hispanic?
It's black.
What is he wearing?
He's wearing a black leather jacket, a black bomber hat.
Black, what kind of hat?
Like a bomber hat, like the ones that have the ears, like that you can fold down.
Black leather jacket, black hat, and what else?
And like flannel printed pajama pants.
And what is he doing?
He keeps going to this guy's house. I know him. I know the resident. He's Caucasian. And he's going up to the house and then going along the side of it and then coming to the street and then going back to the side of it. I don't know what he's doing. I don't want to approach him personally. If you have an officer available, I'd probably have him stop on Reinhardt across the street from Walter Meets Bentley and go around the back.
Okay, George, what's your telephone number you can be reached at?
407-435-2400.
Okay, we'll get one out there. Thanks for calling.
Thanks.
Bye.
Because that is all fine.
Okay, thank you. I'll go ahead and review the testimony in the case law, and in conjunction with the state's exhibit that they're seeking to introduce, we will readdress this issue later. Right now, if we're ready to bring in the jury and have Ms. Rumpf continue the testimony on other matters.
If I can have just maybe 5 minutes or so to make sure that I can queue up the different set of calls and things like that.
You want to take a 10-minute recess?
Thank you, Your Honor.
Okay, court will be in recess for 10 minutes. be seated. Are we ready to bring the jury in?
Yes, Your Honor.
Okay, let's go ahead and bring the jury in. Is Ms. Rumpf available?
She is, Your Honor. We can call for one alone. Jurors are present, Your Honor.
Please be seated. Welcome back, ladies and gentlemen. And while you're getting settled in, I'm going to ask you my questions. If your answer is yes to any of the questions, please raise your hand. During the overnight recess, did any of you have any discussions amongst yourselves or with anybody else about this case? No. And no hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No. No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology? No. No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No. No hands are being raised. Okay, we're going to continue with the testimony of Ms. Rumpf. I will remind you that you are still under oath. You may proceed.
Thank you, Your Honor.
Morning, Matt.
Good morning.
I'm going to move for the moment to you referenced a series of 911 calls from the night of February 26, 2012, and specifically I'll direct your attention to exhibits 158, 159, 160, 161, and 162, 163, all currently stipulated into evidence. You prepared and recognized those records?
Yes.
And are those the recordings as well as the Sheriff's Department notations and reports affiliated with those 3 phone calls?
Yes.
Okay. Is one of those phone calls referenced as a call by Ms. Lauer?
Yes, sir.
Could you tell us the number affiliated with that one, please? It should be on the red sticker.
Yes. Just one moment. Number 158.
Okay. And is Exhibit 159, is that the written portion of that?
Yes, that is the CAD screen.
And when you say, talk about the CAD screen, what I'm interested now is, do you have the ability, based upon the records maintained by the Sheriff's Department, to tell us when a phone call, number 1, connects and then is answered and then disconnects and any actions taken? Can you tell the times that those events occur as it relates to each 911 call?
Yes.
And I think you testified earlier that as to 911 calls, there's actually a caller ID feature so that you know the identity and number of most of the callers as soon as the connection is made.
Yes, that is correct.
Okay. Yes, ma'am? Could you tell me, as it relates to Exhibits 158 and 159, and I'm going to start with the Lauer call, can you tell us what phone number that call was made from?
Yes, it was 407-701-8991.
And explain for the jury briefly, if you would, the difference in the times that we talk about, whether it's connect, times that are dispatches, that sort of thing, and then the difference as to the disconnect time.
As I explained yesterday, the connection time is date and time stamp. That was February 26th of 2012. And the connection time is the time that we picked up the phone. The created time is the time that that call taker or that dispatcher sent that call in for service or made some type of function with that call. But it was the time that that call was actually, I also referred to it as EVA, which you'll see later. The event was added for a call for service.
And as for the disconnect times, were you also able to review the Sheriff's Department, the Seminole County Sheriff's Office records to determine the disconnect times for those calls?
Yes, sir.
I'm going to focus for the moment again back on Exhibit 158, the Lauer call. Can you tell me the time that that call connected to the 911 system?
Yes, that call connected at 19:16:11.
So that's 7:16 and 11 seconds p.m.?
Yes.
Can you tell me what time it disconnected?
I would have to refer to your records because I don't have that here.
Okay. What time do you show a dispatch there?
On this particular event, as we referred to yesterday, this event was a duplicate event due to we had several calls coming in regards to the shooting. So this event was created and then duplicated out to another event. When I referred to that yesterday, when you get several calls and you're connecting them, that is what this call was.
And what time was that done?
This was created and duped out to another event at 19:16:35.
I'm sorry, you said you need to look at a different record for the disconnect time?
Yes, sir. I think you have that.
Let's move for the moment to 160.
Okay.
Is that the Surdyka call? And for the court reporter, that's SURDYKA?
Yes, it is.
Can you tell me the connection time for that one?
The connection time is 19:17:06.
And can you tell me how long that call lasted?
I cannot tell you the duration without the other record.
Can you tell me the event number associated with that one?
Yes, the event number is 2012-057-1680.
Is that a different number than the Lauer call in 158?
Yes, it is.
Let's move to State's Exhibit, is it 170? Sorry, is it 162, the good call?
162 is good.
Okay. Can you tell me the event number affiliated with that one?
The event number is 20-012-057-1686.
And what was the connection time?
The connection time was 19:17:15.
And the phone number that that one came from?
Could we approach for just a moment, John?
Yeah.
Ron, that last question about
Phone number, please disregard that, okay? Just to recap, the Lauer call connected at 19:16:11, the Serdica call at 19:17:06, and the Good call connected what time?
1917-15.
Your Honor, no further questions at this time. Again, subject to potential recall.
Cross?
Thank you, Your Honor. No questions.
Okay, none at this time. Okay, Ms. Rumpf, you're excused from the courtroom at this time, but you're subject to being recalled. Thank you. State, please call your next witness.
Wendy Dorable. Wendy Dorable.
Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Good morning, Mayor. Can you please tell the members of the jury your name
Wendy Doibel,
and where are you employed?
the Sanford Police Department.
May I please have you spell your last name for the record?
Sure. D like David, O-R-I, B like Victor, A-L.
And how long have you been employed with the Sanford Police Department?
A little bit over 5 years.
All right. And your current position there is what?
I am the accreditation manager.
And give the jury an idea of what your duties are as the accreditation manager.
Pretty much my job is to make sure that we meet the standards every 3 years through the Commission of Florida accreditation.
All right. Let me turn your attention to February of 2012 and the dates prior to that. What was your position then?
I was a volunteer program coordinator.
And what were your duties as a volunteer program coordinator?
To recruit and train police volunteers for Citizens on Patrol and for office volunteers as well.
All right. Did you also work with the Neighborhood Watch program?
Yes, I sure did.
All right. And how long had you been working with the Neighborhood Watch program?
Since I started, I kind of had my finger in Neighborhood Watch since 2008.
And just give us an idea of what your specific duties were coordinating between the police department and various Neighborhood Watch programs.
Pretty much the community will contact me who wanted to start a Neighborhood Watch, and my job was pretty much to help them coordinate that. So I would give them information as what is Neighborhood Watch, what the program is, and help them set that up in their neighborhood.
All right, and tell the jury, what is a Neighborhood Watch program?
Neighborhood Watch is a program that's run by community volunteers in the neighborhood who are community members who are interested in deterring and preventing crime in their community.
And what would you do specifically to help a community form a Neighborhood Watch program?
Typically what I would do is when they contact me, we'll schedule a presentation, and I will go out to the community and do a presentation about what Neighborhood Watch is, how to get involved with Neighborhood Watch in your community, and how to get to know your neighbor to prevent crime in your community.
Are there positions within the Neighborhood Watch volunteer program?
Yes, they are.
And what are those?
One is the Neighborhood Watch coordinator, one is block captains, and then there's the Neighborhood Watch participants.
All right, I want to just take those in order briefly. What is the duties and responsibilities of a Neighborhood Watch coordinator?
The coordinator serves like a liaison to the police department, so pretty much they would be the ones that would have contact with me as far as if they need any further training as far as crime prevention methods or techniques.
And a block captain, what is that person's duties and responsibilities?
The block captain will serve more as getting people in their block more involved in Neighborhood Watch, sharing the concept of Neighborhood Watch, and encouraging everyone to report suspicious activity.
All right, in the third category were participants?
Yes.
And what are their duties or roles?
Their duties is just to be the eyes and ears for law enforcement is report crime as they see it, report suspicious activity to 911 and non-emergency dispatch.
All right, and I think you said when you start up a Neighborhood Watch program, you actually go out to the community and give them a presentation?
Yes.
What areas do you cover when you make such a presentation?
We cover everything in crime prevention. We cover the duties. We cover how to be part of the community, getting engaged. When I first come out to do a presentation, the first thing I do is I have every resident there introduce themselves and let us know what their number one concerns are in the community.
And you actually give a PowerPoint presentation at those startup meetings?
Yes, I do.
Do you also provide the participants with any sort of paperwork?
Yes, I usually provide a lot of handouts.
All right, and what types of things do those handouts cover?
Pretty much how Neighborhood Watch works, the history of Neighborhood Watch, preventing crime in your area, how to make your home more secure, preventing burglaries, how to get your neighbors engaged, stuff like that.
All right. Do you address specifically what a Neighborhood Watch person is to do if they see someone acting suspicious?
Yes, I do.
And what is that?
If someone is acting suspicious, you call 911 or non-emergency dispatch.
Do you tell them to do anything else at that point?
No.
All right.
They're the eyes and ears.
In that instruction, is that also part of the written materials?
Yes.
All right. What do you tell volunteers about following someone they believe might be involved in criminal behavior?
We tell them they don't do that. That's the job of law enforcement.
And what do you tell Neighborhood Watch participants about confronting someone they might be involved in criminal behavior?
Not to confront, to let us to the job, let the police department to the job.
Specifically, did you have any involvement with the formation of a Neighborhood Watch program in a community in Sanford known as the Retreat at Twin Lakes?
Yes, I did.
And what was your first involvement with forming a Neighborhood Watch program in that community?
I got a phone call from George Zimmerman.
Did you eventually meet George Zimmerman?
Yes, the day of the presentation.
All right. Do you see that person in court this morning?
Yes.
Could you identify where he's sitting and what he's wearing?
He's sitting over there with a, I think it's a suit, just stood up.
Is the gentleman standing up?
Yeah.
All right. Your Honor, to ask that the record reflect that the witnesses identify the defendant.
It will so reflect.
And when was it approximately that you first had that phone call, that first contact from the defendant?
Sometime in August. I don't remember the exact date.
August of 2011?
Yes.
All right. And then did that lead you to do a startup presentation in that community?
Yes, we had a few phone calls between the presentation, trying to schedule a date.
That is you and the defendant?
Yes.
All right. And as a result of that, was a presentation meeting scheduled?
Yes.
And what was the date of that meeting?
September 22nd, I believe, of 2011.
All right. And where was that meeting held?
It was at the clubhouse at the Retreat, Twin Lakes.
And what time of day or night would that have been?
Probably about 7 p.m.
And was the defendant himself present for that meeting?
Yes.
Did you speak with the defendant at that meeting?
Yes.
Is that the first time you had met the defendant in person?
Yes. Our communication was between either phone or email beforehand.
Was the Homeowners Association president of the Retreat at Twin Lakes complex also present at that meeting?
Yes, he was.
And what was his or her name?
Don O'Brien.
And approximately how many other residents attended the startup meeting?
About 25 approximately.
And those would have been all residents of the Retreat at Twin Lakes community?
Yes.
All right. Did you go through the PowerPoint presentation at that meeting?
Yes, I did.
Did you also provide the written materials at that meeting?
Yes.
Was anyone named the Neighborhood Watch coordinator for that community at that meeting?
Yes, but it was even before then that Mr. Zimmerman was a Neighborhood Watch coordinator.
The defendant was the Neighborhood Watch coordinator?
Yes.
All right.
He had told me he was asked by his HOA to coordinate and he pretty much was going to take the role of the coordinator.
All right, and he agreed to do that?
Yes.
All right. Did you give any additional materials to the defendant because he was the Neighborhood Watch coordinator?
Yes, the day of the presentation I gave him a coordinator's handbook for Neighborhood Watch.
And why do you give that particular handbook to the coordinator?
Because part of their responsibilities, not just as liaison, is to also share the crime prevention concepts within the publications, and also is to coordinate the actual neighborhood watch and to coordinate all the block captains in there.
All right. Your Honor, may I approach the witness?
Yes, you may.
Mr. Dorval, let me show you what's been moved into evidence as states 189. Do you recognize that?
Yes.
Okay, would you examine the contents, just pull that out and examine the contents to make sure it's complete? And as you're doing that, what do you recognize states 189 to be?
Is the Neighborhood Watch Coordinator's Handbook?
And would that be a copy of the handbook that you gave to Mr. Zimmerman at that first meeting?
Yes, it looks like all the pages are here. It's complete. Yes.
Appear to be complete? Mm-hmm. All right, let me show you 190 and ask you to examine that. Do you recognize 190?
This is the PowerPoint presentation I provide to neighborhood.
All right, and would you examine that too?
Sure.
Is that also complete?
Yes, it is complete.
All right. Let me ask you to look at the screen. States one. Yara, could you hit the lights, please? Thank you. States 191. Is that particular PowerPoint slide contained within the presentation that you gave to the defendant and the other members who attended the Neighborhood Watch meeting at the retreat at Twin Lakes?
Yes.
And what did you explain to the defendant and the other attendees about that slide?
Basically that they are the eyes and ears for law enforcement. They're an extension of law enforcement. That they're not supposed to take matters into their own hand. And they call 911 anonymous dispatch to report suspicious activity and to let law enforcement take the risk of approaching a suspect or...
All right. And if anyone at the meeting would have had a question about that concept, would you have answered that question for him?
Yes.
Let me ask you to look at States 190. Is that a page of the handout in the coordinator's handbook?
Yes, it is.
All right. And specifically on the right-hand side, I'm circling it with my laser if you can see it. Bullet point number 10. Explain to the members of the jury how you explained bullet point number 10 or what that addresses.
Basically, it talks back about the responsibility of law enforcement is to apprehend and question any suspicious person or suspect. It's not their responsibility.
And again, furthering the concept that the volunteer is the eyes and ears, but it's the police who actually do the confronting and engaging.
Correct.
Right. And that handbook, or that page of the handbook, was furnished to this defendant?
Yes, sir.
All right. You may turn on the lights, please. Thank you. Did you ever tell the defendant or anyone else at that meeting that it was okay to follow someone that they thought was acting suspicious?
No, not at all.
Did you ever tell the defendant or anyone else in that meeting that it was okay to engage someone they thought was being suspicious?
No.
At that meeting on September 22nd of 2011, did the defendant share with you what his major was in his education?
Yes, he mentioned it was criminal justice.
And as you described earlier in your presentation to the volunteers at retreat at Twin Lakes, did you share with them what they are to do if they see someone involved in what they believe may be suspicious or criminal behavior?
Yes, it's called 911 and non-emergency dispatch.
All right. Is there a distinction that you told them between the time that they should call 911 as opposed to the time they should call the non-emergency number?
Yes, it is.
And what is that distinction?
Pretty much, you give them a scenario. Basically, if you come home and in your balcony you notice that your bike is missing, that's a non-emergency dispatch call. You don't need immediate police to be there. When you call 911 is whether property, your liberty, or someone is it's property, liberty, or you are in some kind of physical danger that you call 911. So there's a big distinction there. But overall, I tell them, if you don't know, just call 911. Don't try to figure out, should I call this one? Don't hesitate. Just call 911 if anything.
All right, and when you conducted the startup meeting at the retreat at Twin Lakes, were there any uniformed police officers from the Sanford Police Department present?
Yes, there were.
And is that standard procedure to have someone, an actual certified law enforcement officer, at the meeting?
Yes, it is, because we want to get the community service officer engaged with their community. So we want the community to know who their officers are.
Do you recall specifically the officer or officers that were present at that meeting?
Yes, it was Sergeant Paul Herks and Officer Buchanan Clapp.
All right, and after the meeting in September of 2011, did you continue to communicate with the defendant about crime issues in the retreat at Twin Lakes neighborhood?
He did initiate a contact with me maybe a month or two after that regarding a burglary that had occurred previously.
And what was the nature of the contact? Did he visit you? Did he call you?
It was an email.
All right. And did he in fact email you multiple times about issues within the neighborhood?
After the presentation?
Well, before and after.
Yeah. The first time he emailed me was about starting the neighborhood watch, and basically saying there were several burglaries that had occurred in his community. He was concerned about them.
All right. Your Honor, thank you. That's all I have.
Thank you. Cross?
Good morning.
Good morning.
If you'll excuse me just for one more minute.
Sure.
When I'd like to approach the clerk, I'd like to have.
You may do so.
And I have a cough drop. I'm fighting off something. I'm going to get rid of that too. It might be a little longer. All right, here we go. My name is Don West. I represent Mr. Zimmerman along with Mr. O'Meara. Ms. Dorval, let's talk just a little bit more about your role with Neighborhood Watch.
Okay.
Is it basically your job when somebody expresses an interest in the program to be the contact person with the Sanford Police Department to set it up and sort of monitor it along the way?
Yes, it was.
And you've done that kind of work until your recent job changed for, what, 4 or 5 years?
Yes, and before that at a different law enforcement agency in the Northwest.
So that's something that you're familiar with, not just with Sanford Police, but with other agencies as well.
That is correct.
So you've done that lots of times, I take it, presentations.
Yes, I've done several presentations, different presentations.
The presentation that you gave to the Homeowners Association in the fall of 2011, is that sort of your standard presentation?
Yes.
And the PowerPoint reflects the kinds of slides that you go through?
Yes, a standard presentation for a Neighborhood Watch startup.
About how many pages are in the presentation? We only saw one here today.
There's several pages. I can't tell you how many offhand. I think it's right here, the presentation. You want
Give
me
me
to
an
count
idea.
them?
Sure. In fact, you're welcome to, if you would, without spending a lot of time at it, just kind of walk through it briefly when you're there with the group, how you introduce the concept and what you tell them you want them to do for you as part of the Sanford Police Department.
Uh, 25, with the cover in the last page.
And the presentation takes about how long?
I usually tell people who are coordinating the event to give me about an hour, because I like to do the introductions first to get neighbors to get to know each other, because that's one of the main priorities that we want to establish, is that neighbors get to know each other and get to talk to each other, so they can watch out for each other.
So the idea is to not just have you explain how the program works, but to generate interest?
Generate interest, enthusiasm, and also to get them to talk to each other. A lot of neighbors don't talk to each other these days. So just to get them to share with each other, look out for each other, and to care about one another.
And that requires, I guess, some proaction, some proactive work.
Yes, and that's why what I do during the beginning is to just let them introduce themselves, you know, where about they live, and also talk about the number one concern, so they all know that they might share that same concern, so they have something in common.
And then what leads up to the meeting that you have, I take it, is you have been contacted by somebody on behalf of a homeowners association. In this instance, Mr. Zimmerman was asked to be that person?
That's what I know of, yes.
Okay. So he initiates a call by email or a contact by email or phone.
Yes.
And then you and he sort of coordinate the business of you making the presentation.
I believe my first contact with him was by phone, and he was expressing to me the issues that had gone in his community and how concerned he was with it, and the HOA as well, and how the HOA had asked him to kind of be the steering person to take this on and bring it about the community.
And was he polite and courteous and respectful?
Yes, every time.
You said part of the reason you have the meeting is to generate enthusiasm, of course, but that requires, I take it, that there be some people there.
Yes.
So how do you do that? How do you help get enough people there that they can hear your message?
That's where the coordinator, or the person assigned to get the meeting started, helps me out in. So one of the things I did do is I provided Mr. Zimmerman with some flyers. I think it was either 200 or 300, I'm not sure, and he passed them out for us and generated that enthusiasm for people to get there.
And that would be something that you would want him to do and ask him to do?
Exactly.
So as far as you know, he did that because there was a pretty good crowd?
Yes. Some people would say no, but I would say that was a pretty good crowd.
20, 25 people?
Yeah, approximately.
Do you know how many people lived in the community?
I believe there was somewhere between 200 and 300 homes. I don't remember.
So plus, I guess, however many people lived in each home, so several hundred residents in the community?
I would say so.
Sure. So, at the meeting, once you've been able to generate enough interest to make the presentation, do you have a conversation with the residents that are there about any issues they may have with crime in the neighborhood and why it is they wanted a neighborhood watch to start with?
Well, at the end, when everyone introduced themselves at this particular meeting, the number one common issue was burglaries. They had several burglaries that summer, and that was the original reason why I was contacted, and that was the number one concern for most of the residents there.
And in anticipation of a presentation in a specific community, you sort of look into that, don't you?
I sure did, and I noticed that there were several burglaries before I arrived there.
So you can sort of look where crimes are occurring by some computer mapping software?
Yeah, we have a crime mapping software.
And you were able to verify, indeed, there had been a number of burglaries in this community?
Yeah, I knew that before I went to the meeting.
So you knew the concern was real?
Yes.
Was there some concern at the meeting about an unsecured access point to the community?
Yes, there was.
Can you describe that a bit?
Something about, either a gate not working or not having a strong enough fencing around the home. So there were some issues that they had with the HOA in particular about some kind of fencing that wasn't working. They had some issues about lighting and just the perimeter of the property.
The perimeter being the outside area.
Yes.
And are you saying that one of the issues was that part of the perimeter was not secured by a fence so that people from the outside could simply walk into the community without going through the gate?
Yes, that was a concern because they felt that people were coming through there committing burglaries through those unsecure areas.
Mm-hmm. So the concern was people could basically sneak in and then do whatever they were going to do and sneak out without going through either of the entrances.
Yeah, either of the secured entrances that they have because they're a gated community.
Okay. I take it that's not something you can help with particularly?
Not particularly. What I could do is I could offer suggestions to the HOA about security and lighting, and just based on the concepts of SEPTED, I can give them some recommendations. But at that point in the meeting, Mr. John O'Brien said that that was going to be taken care of as far as lighting and some of the fence issues.
You knew Mr. O'Brien to be the president of the Homeowners Association?
Yes, I made him the date of the presentation.
So there was the perimeter access issue, and there were also some lighting issues that residents were concerned that there was inadequate lighting in certain parts of the community. Do you know where that was?
Not particularly. I wanted them to take me there, but at that point it had gotten too late to do that.
Anybody mention in between the backs of the houses that there's no street lights or other kinds of lighting?
I believe that was mentioned, that there was poor lighting.
So Sanford Police doesn't supply lights, I take
No,
it?
we don't.
Okay. So you could raise that issue and say, yes, indeed, that is a legitimate safety concern. So as the Sanford Police representative, you recommend they address it?
Yes, but they don't have to.
Of course.
Yeah.
Of course. And the same way, I take it, with the perimeter fence or lack of it.
Exactly. They had another issue with, another issue that came up to mind with the burglaries was the patio doors. There was like a hinge that would always pop open, so a lot of the burglary entries were done through the back through a patio door. So there was that concern too. So I recommended that they go to Lowe's and get this locking device. It's kind of a lever to lock that patio door. I think it was an issue just with the development.
By the development, did you understand this community to be a townhome community?
Yes.
And that there were buildings that might contain several townhomes?
Yes.
Around this larger community of about 300 homes?
Yes.
So if I hear what you're saying that all of the houses or the townhomes would have that same sliding glass door issue.
Yeah, but not everyone complained about it. There was a handful of people that did. So some people might not have that issue, but it seemed like it was a common issue that I thought was interesting just because it was a fairly new development.
With your training and experience, you knew there was a pretty simple, inexpensive fix.
Yes. There's a bar at Lowe's they can get. It's a locking mechanism that they can fix that with.
And with that device in place, for example, it's pretty hard to get in one of those doors.
Well, they could always smash the window.
Of course.
Yeah. that's.
But they can't pry the lock
They can't
quickly.
lift it. Usually patio doors can be lifted off the rails and be just pushed out with no one even noticing that someone's coming into your home.
Did you give them other similar tips about common issues to be aware of for safety of person and property?
Yeah, we kind of, in the presentation, we talk kind of a broad range of crime prevention stuff. So I try to give them as much information as I can in the hour I have because I want to try and enable them to really help prevent crime in their homes, as far as, if you have floodlights in the back or if you keep your light on or locking your door. That's the simplest thing I can tell someone. Lock your door. No, so many people don't lock their front door. So I just try to really pump them with a lot of information in the short time I have.
Some of it's, I take it, pretty common sense.
It is, but sometimes people have to be reminded. Sometimes we just get careless.
You lock your door, you keep your windows shut.
Yes.
You have a deadbolt installed if you don't have one.
Yes.
That sort of stuff. How about if you're stepping away from home, close the garage door?
Yes, that's a common one. People leave the garage doors open, or if they are home, they leave the garage door open, and all of a sudden the lawnmower is missing.
So, as part of your presentation, you are, in addition to generating the interest to make the community neighborhood watch more active, you're also providing some specific tips.
Yes.
Okay. And did you do all that at the meeting there at Retreat at Twin Lakes?
Yes, pretty much.
And answered individual questions that some of the residents may have had about specific security issues?
Yes.
Did someone mention to you that there had been a home invasion burglary?
Yes.
Sustained.
Your Honor, if I could be heard briefly.
Well, it's not a court statement made by somebody who's not here to be cross-examined, so it is hearsay.
Admittedly, it is. I think there's an exception because this witness has been called to talk about her role in the community and why she did certain things.
And she can do that without saying what somebody reported to her. So the objection is sustained and my ruling remains.
Thank you, Your Honor.
Thank you.
Based upon what people told you they had experienced in the community, would you then give advice, maybe specific advice, about how to make their home more secure?
Yes, that bar was one thing. We did have a resident who was pretty upset because someone in daylight had come into her home and attempted to burglary, and she had a small child. And she was really upset about that during the presentation, and that's one of the things that I would talk to. I try to tell them, I believe, I don't remember quite right if they entered through the back or if they entered through the front and she had the door unlocked, but she was upstairs. That was one instance where there was a burglary, and someone entered her home, and she was very frightened by it, and she shared that experience at the meeting with us.
Was she very scared?
Yes, because she had a baby. She was alone. It was just her and her baby, so it was very terrifying for her.
It was evident to you that she was still traumatized?
She was still shaken up by it, yeah.
Do you know how recent that event may have been to your presentation?
It was very recent because it seemed very fresh to her, so I believe it was within a month.
Mm-hmm. Is the emphasis on communication, that aspect of it, is that to get the neighbors to be aware of what's happening at the other neighbor's property?
Yes, that's a big part of it.
Explain that a little bit more.
Okay. Well, being part of a neighborhood watch, the best thing about it is to let neighbors know what's going on so you can protect yourself. So if you know that your neighbor next door has had a burglary, then you can be more aware that, hey, this is occurring, I need to lock up my stuff. But also, as a neighbor, you can look to see if there's anything suspicious going on, at your neighbor's house, or if there's something going on that, someone that doesn't belong there, or something that seems odd to you, to report it.
Do you encourage neighbors to tell each other about anything suspicious?
Yes, to share all the information you can, and whether you see anything suspicious, if any crime has been committed, just keep those lines of communication open.
And if there are safety concerns or some issues, maybe not rising to the level of a call to the police, but a safety issue that might relate to something you said, how do you learn that?
I don't understand the question.
I'll be more clear, I'm sorry.
Okay.
Is the neighborhood watch coordinator the person that is sort of the focal point where this information funnels to?
Yes.
Explain that.
Neighborhood watch coordinator is a liaison. So basically, the neighborhood watch coordinator would be the contact for the police department. For example, let's say the neighborhood watch coordinator at a community calls us, hey, Wendy, we're having a lot of issues with internet safety. Our parents are concerned that their children are online doing things. Can you come out and do a presentation on internet safety? So they'll coordinate that. Or they'll call me and say, hey, Wendy, we had this burglary 2 months ago. I heard from another neighbor that there was a suspect. Can you confirm that? What's going on with that case? So it's kind of, they serve like a liaison for information. So I don't have, 40 people calling me asking me the same question. One person can call me and they can relay that information to all their neighbors.
So in this instance, George Zimmerman was the person that the neighborhood was told to contact.
Yes, he was a neighborhood watch coordinator.
So when they had an issue, instead of calling you, they were directed, call Mr. Zimmerman, and he will be the person that gets in touch with you.
Yes, if they wanted anything, any kind of special training, or they wanted to get some feedback on a case or whatever, then yes, that would be the case.
And that's the way it's designed to work.
Yes.
And that's the way it did work.
Yes, basically a liaison is assigned, that's the coordinator.
After you made your presentation, you continued to have some contact with Mr. Zimmerman by email or phone.
Yes, actually, not that long. I'm not sure how long after, but he did email me about a certain burglary that had occurred.
Mm-hmm. And that's what he was supposed to do.
Yes.
You mentioned that Mr. Zimmerman had, in some conversation with you, that he was, or at some point had been, a criminal justice major.
During the presentation, he mentioned that, yes.
Uh-huh. And did you think that was a bad thing?
No, I thought that was great. Actually, I wanted to recruit him to be a citizen on patrol volunteer for the San Francisco Police Department, but he said no.
Tell me what that program is.
Okay.
Citizens
on Patrol.
On Patrol.
So Citizens on Patrol are police volunteers who go through a 4 to 5 week training program through the San Francisco Police Department. They have a polo shirt kind of uniform, and they drive in Citizen on Patrol vehicles with amber lights. That program, the Citizen on Patrol volunteers are part of an extensive background check. They go through the training, they go to field training before they go out and patrol their neighborhoods.
So you coordinate that program separately and distinctly from the Neighborhood Watch?
That's actually my role in the police department. The Neighborhood Watch stuff I just did because I enjoy doing Neighborhood Watch.
Mm-hmm. There was nothing about Mr. Zimmerman's demeanor, manner of interacting with you or others that you noticed that made you raised any red flags about him. Indeed, you thought that he might be a good member for your other program.
Yes, he was very professional with me. He seemed a little meek to me. He just seemed very, he seemed like he really wanted to make changes in his community to make it better.
Were you aware of him also working and being married and having other responsibilities in addition to being a Neighborhood Watch volunteer?
I knew he was married. That's about it. He had a business, but I didn't know the details of his business. We didn't get into that.
And you knew him to be a resident?
Yes, he was a resident, a concerned resident.
I think I heard you say, but if not, I'll clarify. You are not a sworn police officer yourself, is that correct?
No, I'm a civilian staff.
But you have worked in police departments for a number of years?
Yes, since 1998, minus 2 years that I worked for the state.
And in this particular instance, I take it, and maybe others, you would take a police officer with you to the presentations?
The way I generate that is I will let the lieutenant or the captain know, I'm going to have a neighborhood watch meeting, and the department would always want presentation there. And it really goes back to community policing. The officer has to know who the residents he serves. So it's really a great opportunity for residents to get to know their police officer, and for the officer to know who belongs in that community as well.
The police officers that went with you, did they work that neighborhood, if you will?
The officer, Buchanan Klepp, he did at the time, and the sergeant that was there, he was a supervisor that day for patrol. So I'm not sure whether that was his assigned area or not.
Mm-hmm. Excuse me, I'm going to grab some water.
Sure.
Help yourself if you care for some. Too.
Okay.
Thank you. I'm fighting a little bug here. As a civilian representative of the police department, do you, as part of your presentation, give lessons in law?
No, we don't talk about law, like what statutes are, no.
Right. You don't say, for example, legally, for example, that someone may follow someone to gather information to report to the police.
No, the only statute we go over is a burglary statute and what constitutes a burglary. But we don't get into any kind of law.
So you say, for example, you shouldn't follow somebody, but you're not saying that if you see somebody suspicious, you can't follow at a distance to gather information to provide to the police.
No, I don't.
You're not saying that?
No, no.
Generally, it's a good idea. If you see somebody suspicious, don't engage them.
Exactly.
I take it likewise that when you say on your slide, you're not the vigilante police, I take it what you're saying is you shouldn't be overzealous to act like a police officer to actually engage somebody physically.
Exactly. And I mean, in that same slide, it says you're the eyes and ears. That's really all law enforcement needs, is the neighbors to be the eyes and ears for us.
You're not suggesting in any way that if you are attacked, you're not allowed to defend yourself.
Oh, not at all.
Likewise, there's no discussion, is there, about firearms specifically?
No. There are some meetings that do bring that subject up.
But you don't talk to the residents about whether or not they are allowed to legally carry a firearm?
No, that's not my place to tell them that.
Are you generally familiar with the laws surrounding firearms?
I know the constitutional rights, and if I start talking about gun laws and everything else, I usually start getting in debate, so I don't try to get into that.
Okay. That's not something that you never say, for example, if anybody has a gun that they carry legally, you're not allowed to.
No, I don't say that.
You never get into that at all?
No. I've had people question, I have this, what if I do that, kind of thing.
Of course. So based on neighborhood watch criteria, you ask people to follow the law and to be the eyes and ears of the community, to talk with each other a lot. If they see a crime being committed in their mind, call 911. If you would answer just out loud.
Oh, yes, sorry.
It's a tricky thing with the court reporter.
Yes, I apologize.
And that if you see something suspicious, but you can't necessarily say, I see a crime being committed, you're supposed to call the non-emergency number.
Yes. Sometimes I would get questions like that. People saying, well, how do I know if it's suspicious? I don't want to bother you guys for no reason. And I said, call us anyways. Let us check it out. Let the law enforcement officers check out to see what's going on. Because it could be a bona fide suspicious activity, or it could just be someone that they might not recognize, someone new to the community. So we always encourage them to call.
So that's, in fact, one of the things you say is if you see somebody that you don't recognize.
Yes. So, and that's the important part why I tell neighborhood watchers, get to know your neighbor. Get to know who lives in your community. Because then when someone who doesn't belong there, you can quickly identify them. Hey, wait a minute. I don't know this person. They probably don't belong here. And you can call the police and have them check it out.
Do I take it that the basic way this works, if it's going to work effectively, is if you see anything that strikes you as out of place or suspicious or a person that's unfamiliar, you err on the side of making the call?
Yes.
May I have just one moment? With the idea of someone who seems suspicious, do you talk in some detail with the neighborhood, the neighbors, the residents, about the kinds of things that might be suspicious? For example, I guess someone you don't know would be one. Someone that's in a place in the community that might be unusual.
Yes. We talk about, if you see a car driving around in circles and you don't recognize the car in your community, that might be suspicious. If people are walking around in areas that are not typically walked on, that could be suspicious.
For example, coming through between houses where there's no sidewalk or pathway.
Yeah.
Mm-hmm. Someone that seems like they're trying to hide.
Yes.
Someone that just seems maybe looking at cars, looking at windows,
yes,
looking at houses.
People peering through windows or peering through the vehicles or trying really hard to not be noticed, kind of thing.
Or people that seem to be doing something that may be a little inconsistent with what common sense tells you people would be doing in a similar circumstance. For example, walking around without any particular purpose in the rain.
Yeah, if you're just walking around in circles, yeah, that would be suspicious.
Well, circles, sure, but just the idea that someone's in the rain and they don't seem to be running or jogging, exercising. They just seem to be in a place in the neighborhood that seems a little wrong, and they don't seem to be having a purpose.
Yeah, if there's no purpose, then, calling 911 or non-emergency dispatch.
Sure. Non-emergency in that situation.
Yeah, because they're not posing a threat,
Not committing a crime, you can see.
Yeah.
Just something about them doesn't seem quite right.
Yes.
Did Mr. Zimmerman have contact with you, and in fact contact with your superiors after your presentation to compliment you on the work that you had done to help them with the neighborhood association?
Yes, I think it was an email to my chief, but I think it might have been before the presentation. I'm not sure. You might want to...
When was the presentation?
September 22nd, 2011.
Madam Clerk, what is the document's exhibit number for identification?
I believe it's Defendant's A.
Pardon me?
Defendant's A.
A. May I approach, please?
Yes, you may.
Ms. Dorval, what's been marked as Defendant's A for identification, and ask you to take a look at it and see if it's something that you have seen before, something you recognize.
Yes, this was before the presentation, and this is George Zimmerman. He wrote an email to Chief Lee at the time, basically complimenting me on my professionalism in contacts with him.
He outlines the letter is to Chief Lee.
Yes.
Recognizing you to Chief Lee for the work that you had been doing.
Yes.
And then, of course, Chief Lee's response copied to you.
Yes.
Let me just focus on the date for a second. I believe you said that the presentation was in late August of 2011?
No, September 22nd, I believe.
Not August 22nd?
I'm not sure now. It was a while ago. This letter came before the presentation, if I remember correctly.
Okay, fair enough. Were you pleased that Mr. Zimmerman took the time and effort to compliment you to your boss?
Yes, I emailed him and told him that.
Thank you. Your Honor, I would move Defendant's A, please.
Any objections?
There is, Your Honor. There's a hearsay objection as to part of it.
Okay, want to approach him? We'll talk about what part.